When we're distinguishing between what's in a contract and what isn't, we need to understand some of the core concepts in law. One of those is the parole evidence rule. Now, the parole evidence rule, it's a pretty fancy phrase, but it just means a simple concept that the law has developed to say when people have taken the time to put a contract down into writing, then if that looks like it's the whole contract, then it will be treated by the courts as though it is the whole contract. And if any oral statements that happened before the contract or at the time of contract conflict with that written document, then the parole evidence rule says that what is written will prevail. So clearly, it means that the written contract overcomes verbal representations or promises in the event of any inconsistency. However, there is a bit of an out, and the out is that the parole evidence rule only applies if that written contract appears to be the complete record of the agreement. So a court can go back and decide and say, you know what, I know that there's a written agreement here, but we really don't think it is the entire agreement. We actually think that there were some very important verbal representations that occurred as part of the bargaining process, and a true meeting of minds needs to include those verbal representations. In these cases, the court's saying that the written document isn't a complete record of the agreement. A case to help us think about that is Van den Eschert and Chappell. So in this instance, we have a contract for the purchase of a house, and our two parties are the sellers, which is Van den Eschert, and Chappell, who is the purchaser. So we've got our purchaser and we've got our seller. And again, this is about the sale of a beautiful house that we have. So the house is going to go to Chappell, and the money's going to go that way. So what actually happens in this case? Well, as part of the bargaining process, Chappell asks, what about white ants? So he says, is there any infestation of white ants, which must have been a bit of a problem in the area? To which Van den Eschert says, no, there aren't. No white ants here. So they enter a contract, but that isn't in the written contract. So you can see the problem now. When we reduce the sale of the house to a written contract, and this assurance of no white ants isn't in the contract, then the parole evidence rule would say, you know what, that assurance of white ants isn't actually part of the contract, so it's not a term. Of course, the house turns out to be infested with white ants. And so Chappell ends up suing Van den Eschert for breach of contract. Now, the court decided in this case that actually the parole evidence rule did not apply. And they said it didn't apply because the written document was not the entire contract. And that in fact, this assurance over here of no white ants was a very important part of the complete record. So that was part of the contract, it was a term, and now there was a breach of contract. What this has led to is that many contracts now contain specific terms, such as specific phrases, such as this contract is the whole of the agreement clauses between the parties, to try and prevent this exception being used. Now note, just because a representation doesn't become a term of the contract doesn't mean that there aren't other options available to a party who gets harmed by this. There are issues around consumer law, which we're going to come to in week 10. We've looked briefly at misrepresentation in week 8, And now we're going to move on to a third of those areas where something is open, even if it's not a term of the contract, which is a collateral contract. So a collateral contract occurs where we say that even though the representation made by a party doesn't form a part of the contract, say because it's not in writing, the courts construe two contracts where they say it's where the representation or promise of one party is made, and the courts construe that as their consideration, and the other consideration is that the other party who's subject to that representation enters into the contract. So when that representation turns out to be untrue or the promise is broken, the other party can sue for breaching the collateral contract. This is probably a bit easier to explain with a case. De La Salle and Guilford is a pretty good case. So in this case, De La Salle agrees to lease a house from Guilford. So again, we've got our nice house, agreed to lease it, and before signing the lease, De La Salle asked Guilford if the drains were in working order. So are the drains working? Is the big question that gets asked because maybe they looked a bit dodgy. To which Guilford, of course, replies, yes. As you can guess, they weren't working. In fact, it turns out that they were blocked. Now, because of the parole evidence rule, the court says that statement is not a term. Statement is not a term. So even though he said that they're working and they're not, the courts invoke the parole evidence rule and say, look, there's nothing in this lease that talks about the drains, so therefore it's not a term. And you'd say, well, De La Salle's up the creek then, right? Because there's no term about the drains, and if they're not working, then, more fool him for not having it written into the contract. But what the courts did say was that there was a second contract. Okay, so this is the important point. There is the contract for the lease, but then there was a collateral contract. And the collateral contract was the assurance of the drain as one form of consideration, and on the other side was entering the lease. So what you can see is that the courts have construed this collateral contract as the first contract that comes in place. Once this is in place, then it sets up the second contract, the lease. Now I hope that reversing those numbers doesn't confuse us too much. But they're saying, look, there's a contract here where De La Salle says, look, if you promise that the drains aren't working and to make sure that they're working, then I promise to enter the lease. Promise for a promise? Good contract. Okay, I'll do my part, which is to actually enter the lease. Now, irrespective of the term that's in that lease, even though there is the statement is not a term of the lease, it's actually part of this collateral contract. And because of that, De La Salle can get damages as a result of the blocked drains and can get compensation. Notice that there is a big difference. The big difference is if it had been a term of the lease, he might have been able to get out of the lease. He can't do that. So this is a significantly different outcome. While you might think it's roughly the same outcome, and in many cases it would if they get roughly the same level of compensation. But if De La Salle actually wanted to get out of the lease, under this arrangements, under the collateral contract decision, he can't, because there's nothing actually wrong with the lease. The problem is in the collateral contract down here, which was entered into prior to the lease, so he can only get damages or compensation for the blocked drains. That's what we've got set out there. A collateral contract that gets breached means that you can't terminate the main contract. You can only get damages for the breach of the collateral contract.